This class we will discuss about High Court and subordinate courts. First, we will discuss High Courts. If you take High Courts, there are articles 2142 to 31. Actually, 232 also there, but this was got repealed. This was got repealed. So, Article 214 to 231. This deals with the High Courts. High Courts. So, High Courts there are at states. Okay, and UTs also. Some UTs also covered. For example, Delhi High Court. Then actually, Article 214 it covers for high courts for states. For each state there is a high court. For each state there is one high court. That is what Article 214 says. However, Article 231 says common high court can be there for two or more states. This is as per 7th Constitutional Amendment Act 1956. This is as per Constitutional Amendment Act 1956. That is what Article 231 says. Then Article 215 High Courts to be court of record or contempt of court. So what is court of record? Whatever the record it is maintaining, that will be perpetually it is maintained as the record and it will be followed as a rule. And there is contempt of court. Contempt of court means it is not defined in the constitution as such, but it is given in the act COC Act 1971. And there is a civil contempt and there is criminal contempt. These are all I defined in the previous Supreme Court lecture, so you can watch that lecture. That is Article 215. High Court to be a court of record or contempt of court. That is Article 215. Then Article 216. Then Article 216. Article 216 is the Constitution of the High Courts. Constitution of the High Courts means there is a CJ High Court plus other judges. Other judges. These judges are decided by the President. This is what is given in the 216 article. So CJ High Court will be there and other judges will be there. Other judges are decided by the President. Other judges decided by the President. That is, if you take 124 clause 1, there is 1 plus 7 judges were there earlier. Now it is become 1 plus 33. So this number is decided by the Parliament by law. Parliament by law. But here President will decide. Here Parliament is deciding. Then Article 217, if you take 2171, this is the appointment of the appointment. For example, if you take High Court judge is appointed by the High Court judge when is appointed by the President. By the President. By President will consult the Governor plus the Chief Justice of India. Governor plus Chief Justice of India plus CJ High Court concerned. For example, you are appointing to the Patna High Court. Then you have to consult the CJ High Court of the Patna also when you are appointing this High Court judge. For example, you are appointing CJ High Court. Then President will appoint, but President should consult the Governor plus the CJ. Governor plus the CJ. These two persons are consulted. These two persons are consulted. This is Article 217. Article 217. Article 217 clause 1. Then you go to Article 217, Class 2. Article 217, Class 2. Here, here only you remember, age you remember 62 years. For Supreme Court judge, it is 65. For him, it is 62. And resignation should be given to the president. And then removal, as per 124, Class 4. That we have seen already in Supreme Court provision lecture. Then also there is one more thing, he can transfer also. When there is transfer, as per triple two, as the article triple two, there is transfer of the high court judge from one high court to the other high court. Then also there is a vacancy, so that can happen. Then article 217, class 2, there is a qualification. So what is the qualification? If you take qualification, he must be citizen first, okay, plus he can be a 10-year judicial office he can be holding, or 10 years he can be advocate in the high court. So these are the two conditions, this or this. So he must be citizen plus 10 years judicial office he must be holding, or 10 years advocate he must be holding. That is 217 class 2. 217 class 3, it is the age of the high court judge. It is decided by the president, okay, and but president will consult the CGI. That is article 217 class 3. Then article 218 is very simple. Article 218 says 124.4 and 124.5. 124.4 removal of Supreme Court judge. 124.5 Parliament by law regulate removal of Supreme Court judge. So these two will apply to the High Court also. These two apply to High Court also. That is Article 218. Then 219 oath. So oath is made by governor. Oath is made by governor or person appointed by him. That is for Supreme Court judge, president or person appointed by him. Supreme Court judge. This oath, Supreme Court judge oath 124 class 6. Next 220 restriction on practice. So he cannot, same high court he cannot practice after retirement, but he can practice, at other high courts, also at Supreme Court, at other high court, at Supreme Court. That is 220. Then 221 salaries. Salaries decided by the Parliament until then as per second schedule. Then 222. 222 says there is transfer of the judge. Transfer of the judge. And 222 says transfer of the judge is happened. Then 222 says there is allowance, compensatory allowance is given whoever is transferring, but this is determined by Parliament by law. Until then, President by order. President by order fix that the allowance. That is 222, Article 222. Then 223 acting CJ High Court. Acting CJ High Court. Acting CJ High Court appointed by the President. Appointed by the President. He is appointed by the President. Acting Chief Judge. When he can appoint? When there is vacancy. or when there is absent, or when unable to perform his duties, then president can appoint a CJ High Court from among the High Court judges available there. Then 224, you remember 224, two people will come here. Additional judges, acting judges. Here acting judges. Here Chief Justice, acting Chief Justice. Here acting judge only. Additional judges is appointed by the president with the consent of the CJI. When he can appoint, when there is increase in business. Business means worker. Increase in business, or when there is arrears. Arrears means backlog. There is a lot of work has been piled up. Then president, after consulting CJ, he can appoint. So this maximum age for maximum for 2 years he can appoint. Maximum for 2 years. Maximum for 2 years. And acting judge means, let's say one judge vacancy is there, okay, or when it is this judge is appointed as the acting judge, acting CJ High Court, or he is not feeling well, he is not come. So then president will appoint this acting judge. So additional judge, president will appoint, but with consultation with CJ. Whenever acting CJ High Court or acting judge, president can directly appoint. CJ permission is not required. CJ permission is not required, or consent or approve that consultation is not required. That is what is there. And anyhow, these two fellows, additional acting judge, beyond 62 years they cannot work. Okay. So additional judge, acting judge, 224. Appointment of additional judge, acting judge. Appointment of additional judge, acting judge. Additional judge, acting judge. When acting judge will come? When there is a vacancy or absent or unable to perform duty, then only acting judge can be appointed by the president. Then if you take 225, existing courts, existing high courts provisions, they will continue. Okay, before constitution has come into force, whatever existing, that they will continue until changed by the law, the constitution, subject to the constitution. So in between here, 224A is there. This is a retired judges. And retired judge, it is appointed by the president. Sorry, CJ. CJ. But consent of the president should be taken. Consent of president. Consent of president. And his allowance is done by president. We have seen this one in Supreme Court. President will decide the allowance. And retired judge should given the consent. Otherwise, you cannot force him. He is retired and happily taking rest. You cannot force him. You just come and work like that. You have to take the consent. That is what is mentioned in the Constitution. Then Article 226. Under Article 226, if there is violation of the fundamental rights or other legal rights, then you can directly go to the High Court. Then you can directly go to the High Court. That is under Article 226. That is, if you take under Article 32, if there is violation of the fundamental right only, you can go to Supreme Court. But if you fundamental right or other legal right also, you can go to the High Court directly. But here you see, here Supreme Court must accept your petition or your case. Here may or may not accept. May or may not accept. High Court. But Supreme Court must accept. That is the difference. So here it is only for fundamental rights. Here only for fundamental rights. Here fundamental or other legal rights also. Then you can go to directly to Supreme Court. That is 226 Article 32 difference. Then Article 227. Article 227, it is a superintendence. High Court have power of superintendence. Super. Just a minute. Power of superintendence over all courts. Means like subordinate courts. Okay. Here Supreme Court will not come. So whatever High Court is there and below whatever any court is there, it will look after. Like superintendent means it will form rules how they have to work. Okay, all that. All courts are tribunals also. How they have to function, what are the fees, what are the procedures they have to follow, what are the forms they follow, what how accounts they should maintain. So everything the high court can form the rules, and it can superintend, and it is having a supervisory role over the lower courts than below the high court. That is Article 227, power of superintendence over all other courts vested in the High Court, vested in the High Court, vested in the High Court. That is Article 227. Then Article 228, transfer of certain cases. Transfer of certain cases. Here what happens? Let's say there is lower courts. Okay, lower court, there is some case pending. Okay, some case is there pending. Okay, then High Court, if it feels this case has some related to constitutional interpretation involves some constitutional interpretation, then so High Court can withdraw that case from there. Okay, this can withdraw from here, decide the case. It can withdraw and decide the case. It can withdraw and it can decide the case, and it can dispose itself. One thing, it can dispose itself, or it can send to the lower court, and the lower court should dispose in that form, in that form, or whatever High Court said, as per that it has to decide. That is transfer of certain cases. Okay, similarly, there is Article 139A. I have not discussed in the Supreme Court. This one I skipped, forgot this one. This also transfer of certain cases related. For example, before Supreme Court or before High Court, any case is pending. Okay, any some specific important case, then Supreme Court can decide that case, and judgment of copy can give to High Court. Then High Court can deliver accordingly whatever the Supreme Court says. That is 139A clause 1. Then 139A clause 2 is there. Like one High Court to other High Court, Supreme Court can transfer any case. That is 139 clause 2. This is the related to Supreme Court. Then Article 229. This is officers and servants. Officers and servants plus expenses. This already I told in for 146 for the Supreme Court. Officers and servants plus expenses. Plus expenses. So here what happened? Officers and servants here. First we will discuss in Supreme Court. They are appointed by the CJ. Okay, or judge nominated by him, or officer nominated by him. Okay, if anyone not already attached to the office, then as president requires, you have to consult the UPSC. That is 146.1. 146.2, conditions of service of officers and servants. This is done by, again, rules done by CGI. Okay, but if anything salary etc is president approval is required. Salary etc president approval is 146.3. All expenses are the charged expenditure. Like parliament, no need to vote. Charged expenditure, that word you remember. Similar thing will come here. Officers and servants. Here CJ High Court or the judge nominated by him or any other officer. Okay, here in SPSC will come here. SPSC, State Public Service Commission, who is not already attached. You have to consult to the State Public Service Commission. State Public Service Commission. Then conditions of service also CJ High Court will decide, and charged expenditure 146.3 expense will be charged expense. That is 229. That is 229. 229. Then if you come to 230, just a minute. And if you come to 230, this is extension of High Court to the Union Territory. That Parliament by law can do that. Parliament by law can do that. Then 231, I already told you, a common High Court for 2 or more states. A common High Court for 2 or more states. A common High Court for 2 or more states. That is Article 231. Then you come to subordinate courts. This is Article 233 to 237. Article 233 to 237. So here subordinate courts means first 233 it will come district judge. District judge. Okay. District judge. District judge is appointed by governor. Governor, but he must consult the High Court. He must consult the High Court. That is what 233(1). 233(2) says what is the qualification. Okay, he should not be already in the service of the union government or state government. He should not be in the service. Plus, he should have as advocate or pleader. He should have not less than 7 years experience. Minimum 7 years experience should be there. Plus, High Court should recommend his name. High Court should recommend. Then only this is the qualification for the district judge. Then Article 234, appointment other than district judge. So here governor will appoint. Here he will consult the High Court. Plus he will consult the State Public Service Commission other than district judge. This is other than district judge. So 233 district judge, 234 other than district judge. How the appointment is done. Then Article 235, control over subordinate courts. Control over subordinate courts vested in the High Court. Vested in the High Court. Control over subordinate courts vested in the High Court. Means like their promotion, transfer, everything. Then Article 236 is related to interpretation. Interpretation. So here two definitions are there. What is the district judge? What is the judicial service? What is the judicial service? So district judge means given additional district judge, city civil court, additional district judge, assistant district judge, like that, sessions judge, additional session judge, like that, they given list. Okay. Then judicial service means less than or equal to district judge and officers below district judge and officers below that. That is what judicial service as per this one. Then article 237 says these provisions means these subordinate codes. Okay, provisions subordinate code provisions can be applied, okay, by governor. Governor can apply these provisions, okay, to any class of magistrate, means to any court or any judge. These provisions can be applied. Who has the power to apply? So governor is having the power to apply. So these are the articles 233 to 237. This is related to uh, subordinate codes. Subordinate codes. So if you see the structure of these, if you see the structure, if you see the structure here, Supreme Court, High Court, after that there is a at civil cases. At civil case, you have district judge. You have district judge or additional district judge. You have district judge or additional district judge. There is no pecuniary limit. Okay, no limit for fines and all. This is in civil cases. For civil cases. Then after that, civil judge, senior division or subordinate judge, first class. Then civil judge, junior division or municipal court. Okay, municipal court or small cause court, we say sometimes small cause court. Okay, this is that lowest level, you can say. Lowest level municipal court is there, small cause court is there. So low limit, low pecuniary. Pecuniary means monetary limit. Amount. It cannot impose huge fines. Okay, it can very little fines. If very small cases, it will take. That is like that. Very small cases. If big amount is involved, that civil cases will go to district judge like that, or senior division judge like that. Civil judge. These are the civil cases. For civil cases, he can no limit here. He has having no limit. He having some limits, and here very small cases will go. That you remember. Then here also you will have sessions judge. Here we call this is the criminal cases. Sessions judge or additional sessions judge. Sessions judge or additional sessions judge. Then after that, chief judicial magistrate. Chief judicial magistrate. Or if you take metropolitan areas, there is metropolitan magistrate. Metropolitan magistrate. Then judicial magistrate first class. Then judicial magistrate second class. So here here you can impose even death sentence, but High Court should confirm it. High Court should confirm it. Then only this can be implemented. Then Chief Judicial Magistrate, up to 7 years imprisonment he can give. Up to 7 years imprisonment and any amount of fine, any fine. And first class up to 3 years and 5,000 amount. This one 2 years 1,000 amount. Judicial magistrate second class. This is the broad structure, you can say. And the appointment, you remember. So sessions judge means, remember, criminal cases. District judge, civil cases. So you can say there is a district session judge. If civil cases, he will act as a district judge. If criminal cases, he will act as a session judge. This you have to remember. So I have discussed here High Court's Article 214 to 231, and then Subordinate Courts 233 to 237. So you watch first Supreme Court provision lecture, then you come to High Court and Subordinate Courts. If you directly watch High Courts, you will not understand because some explanation like collegium system appointment is there. So many of the provisions, whatever applied to the Supreme Court is applied to the High Court also. So many of the provisions are repeated in High Court. So first watch that lecture and then you come and watch this lecture. Thank you.